Car accident lawyers and contingency fee agreements. If you have been injured in a car accident and you need the help of a lawyer to help you settle the case, you may have to pay them a contingency fee. This means that you will not have to pay a fee unless an agreed condition is met. The condition in question is usually the success of your case, which is followed by the payment of a settlement fee. The settlement fee will compensate you for your injuries and any losses that occurred as a result of the accident. If you do not win the case, you will not have to pay a fee. When a lawyer agrees on a contingency fee, they usually think you have a really strong case. If you can, you may wish to hire the very best lawyer you can find, as contingency fees tend to be quite similar regardless of how good a lawyer is. However, you should be aware that although the contingency fee may be similar between lawyers, such as 40% of your settlement, for example, there is no standard contingency fee that is used. This means that your agreement with one lawyer could be different to an agreement with another lawyer. In other words, contingency fees can include a percentage of the settlement figure, whether the case is appealed or goes to court, whether the percentage of the figure changes if the case is appealed or goes to court, whether the percentage of the fee is based on net or gross recovery, whether you are required to pay the lawyer's costs, and which services are covered in the fee. Let's take a closer look at each of these. A percentage of the settlement figure. Contingency fees are usually made up of fees that can range from 1/3 to 40% of the settlement figure. It goes without saying that you will want to pay the least amount of money possible. However, you should not tell your lawyer this. This is because they may not make your case a priority, or they may disregard it. A change in the percentage. Some agreements will include a change in percentage if the case is resolved, and how it is resolved. For example, there may be a specific fee if the case is resolved before it goes to court, but the percentage may increase if it ends up in court. You should be aware that the majority of car accident claims settle without going to court. However, there is likely to be an increase in the fee if the case is appealed. Whether the percentage of the fee is based on net or gross recovery. If a fee is based upon the gross recovery, it will be based on the settlement you are awarded. If a fee is based upon a net fee agreement, your lawyer will be paid out of the amount you are awarded before any legal fee is calculated. Whether you are required to pay the lawyer's costs. Oftentimes you will be required to pay any out-of-pocket costs that arise. However, in the states that allow this, some lawyers are happy to pay these costs, and you'll only need to pay the costs back if the case is won. You should be aware that you may have difficulties finding a lawyer who is happy to handle your case on these specific terms. Out-of-pocket costs typically include charges for getting a copy of your medical records. These charges tend to be $100 or less, and you will have to pay the cost even if your case is not taken to court. If your case goes to court. If your case goes to court, there are a few more costs that you may have to pay. These costs include court paper charges and filing fees, approximately $150 at the time of writing. Discovery costs that include the cost of deposition transcripts, approximately $250 to $1,000 plus depending on the case. Expert witness fees, approximately $1,000 to $5,000 depending on the witnesses. Which services are covered in the fee? Your lawyer is likely to help you resolve any car repairs you have in addition to helping you get a rental car. They may also help you make a medical payments coverage claim that your insurance company will need to deal with. Some lawyers charge for the above services, whereas others do not. Obtaining a written agreement. Many states ask that you have a contingency fee agreement in writing. If your state does not require you to do this by law, you should get one anyway. This is because both you and your lawyer will need to understand the obligations that you both have. Sign the agreement when you hire the lawyer, and make sure you and your lawyer have copies of the agreement. You can negotiate. A fee agreement can be negotiated, and you can propose alternate terms if you wish. If you think you have a strong case and your lawyer does too, they will be more likely to agree to any terms you request.